there in U.S. history a time where the government said, we're going to presume another crime did happen without proving it, to then criminally charge someone with a crime that requires it?
I don't know about in history. I don't know all that, but
it's a big ask, right?
That's a big ask. I have to be a historian for that more than a legal guy.
My understanding is most analyses of this has been, for the first time in U.S. history, a crime which requires a proven underlying crime did not have one. And so obviously the falsification of business records is a misdemeanor, which was beyond its statute of limitations. However, they upgraded to a felony, arguing that there was falsification of business records in furtherance of another crime. The implication being that's an add-on charge when you have an underlying crime. Like a mafioso is going to murder somebody and then falsifies records after the fact. They say, we're adding this onto that charge of that crime you did. You have felonies that couldn't have happened unless the government has proven beyond a reasonable doubt that the first crime actually happened. So my point with all of this is what may or may not be, or what we want to happen, or what usually happens, clearly is out the window.
Right. The intent to defraud here only required that there's an intent to commit another crime or to conceal another crime, right?
Right. So the issue is the government has to prove in all instances if they're accusing you of a crime.
Right. You don't have to prove the commission of another crime, just that it was intended, and that's the difference. So they had to show that why did you conceal those documents, the business records? And the reason is to hide campaign finance violations or whatever they decided.
They're going to have to prove that crime. My view is largely, if our justice system says we can create crimes and charge you with them, that your penalty is upgraded because we implied without proof another crime happened, then our justice system is gone. This is unprecedented. The idea that the state is going to say, and look, we're going to charge you with felonies. We can't unless we prove another crime, but we don't have to prove the other crime. It's an absurdity.
Well, again, it's only the intent that you tried to conceal something else, like a campaign finance violation. You don't have to prove that you actually committed a secondary crime. You just need to show the intent to conceal it, and that's what they did.
So attempted robbery, attempted murder are also charges. If they're accusing Trump of campaign finance I'll put it this way: if someone attempts to evade taxes or attempts to commit campaign finance violations, are those crimes? Like, would the DOJ go after you if you were trying to
attempted to commit election violations?
Yes.
Yes. And when it came to the three possible crimes for Trump, one was that his intent in concealing the business records was to violate the Federal Election Campaign Act. A second one was a violation of New York election law that concerns unlawful conspiracy to promote a candidacy by unlawful means. And the third one was violation of New York tax law.
Go ahead. All right, finish.
What you're saying is you don't like the fact that they didn't have to prove that there was a violation of any of those three crimes beyond a reasonable doubt, and that should be unconstitutional. The courts
I would argue it is. It is unconstitutional. Because let me ask you this. Can the government impose a penalty on an individual at any point without proving they committed a crime?
No, but here the statute says that you just have to conceal the records, which he was proven to do so, and that's just a misdemeanor. But to elevate it to a felony, you don't have to prove a second crime. You just have to prove the intent. You're doing it for a reason, for a bad reason. And when you ask me, are there other examples in the law where that is, I can't name it, but the courts have found that is allowed.
So my understanding, and I'm not a lawyer, but I've just read the various legal analyses on this, both left and right, is that it is the first time in U.S. history an aggravated or add-on charge did not have a proven underlying crime. Now, maybe first time in history is a bold claim, it's an absolute. But my argument would be then, if it is to be argued that the U.S. government or the states have the power to expand or increase your penalties or charge you with a crime without actually proving a component of what requires, then the Constitution is out the window. Then all gloves are off, no holds barred, razor wire in the boxing glove, doesn't matter anymore. The point is this. Falsification of business records is a misdemeanor. Mm-hmm. And if the government can prove you falsified your business records straight up, misdemeanor charge. If they know you did and don't pursue that charge, it goes beyond the statute of limitations. They can't bring those charges later on. If the government can say that falsification of business records in furtherance of another crime. So let's put it like this. Let's segment this. Misdemeanor falsification of business records, let's argue it's a misdemeanor, so it's maximum 1 year probably. On top of that, the felony charge after the fact, in furtherance of another crime, is an extra addition, right? So we've got the base level misdemeanor, the upgraded felony expands the penalty. This would imply the government has the ability to impose penalties on you without proving you committed a crime.
Well, you're proving intent. So compare this to conspiracy. If you guys conspire to rob a bank and you actually don't rob the bank, but you had the intent to do so and you agreed, and you did something like, you bought some rope or something to tie someone up, they can bust you for the conspiracy, even though they never proved that you robbed the bank, you completed it. And all this is about intent. This goes into your mind.
Fair point, but the conspiracy itself is the crime.
That's correct.
So so the argument would be threatening to murder someone is a crime. Murdering someone is a different crime. My point is the government has never proven there was another crime.
Well, remember, we're showing the intent. You don't have to prove another crime. You just have to prove there was intent for another crime.
Right. I understand that. So my point would be the unprecedented case where they upgraded a misdemeanor to a felony to use against Trump, and just moving beyond this, we will also face the unprecedented nature of Trump's DOJ attempting to go after in any way possible. Maybe even it's just to jam up the people who receive these pardons, Fauci being the principal example. They will use, circuitous legal means to go after him in some way.
There are felony statutes on money laundering and fraud where if you have a crime of reporting violation, transactional reporting violation, a seemingly minor offense, but if it's used to do money laundering or fraud, then that too would raise the offense level, just like in Trump's case. So there are other examples where, but I see your problem is that you don't like this whole area where unless you can prove beyond a reasonable doubt a second crime, then they shouldn't be elevated.
Well, it would be like saying the government charged someone with money laundering but never proved money laundering. They said he had a meeting where he talked about money laundering. We could never prove the money laundering happened, charged him, and convicted him.
Well, when it comes to money laundering, if you're not reporting things properly, you can get hit with a lower level crime. But if the intent is to do some major drug dealing, and that's why you're concealing it, the intent there, without even proving the drug dealing, you can still get busted for a higher crime.
I suppose the issue with this is the upgraded charge requires the underlying crime, as opposed to conspiracy, which is the intent.
Well, the intent is all you need in the upgraded crime. You don't need to show they actually committed the election violation beyond a reasonable doubt. You just have to show that the object, the reason why he was concealing, cooking the books, was because he wanted to spend more for the election than he was allowed.
I suppose we'll see, because it's been floating appeal for over a year now, right? Like the judges have heard the case. They've not ruled on it. I think, and then we'll jump to the next story, Snapocalypse. My view of this whole thing, and the reason why I brought it up, was because everything we're seeing is unprecedented. The Democrats going after the political opponents is unprecedented. The arrest of Trump's lawyers is unprecedented. RICO charges for soliciting legal services, unprecedented. I think Trump it might have been like 3 or 4 lawyers who were arrested. And like we've never seen anything. Look, I can't speak for the entire country, for the entire history of the country. So it is a bit hyperbolic to say never. I would say in my lifetime, it is shocking and terrifying when the Democrat DOJ starts arresting the lawyers of their political opposition.
What lawyers were arrested?
Jenna Ellis. There was, I think it was 2 lawyers from the Georgia case and 1 in Wisconsin. Jenna Ellis was the most notable because she ultimately ended up pleading guilty to RICO charges. And the RICO charges stemmed from her drafting a letter. Trump solicited her to draft a legal letter to pursue an election challenge. And they argued RICO because Trump's election challenge was a conspiracy to overturn an election. And because she participated, she had committed a crime.
Well, Jenna Ellis wasn't charged by the Fed, so it wasn't.
Right,
it was by the state. It was state of Georgia. That was Fani Willis's case. And that one was because they charged her with the trying to overturn the election by writing letters and doing all that stuff. That's
lawyers writing letters is a crime now?
Well, it could be, yeah. Lawyers who, like consigliaries for the mafia, have been accused of crimes for many years.
Is it illegal to challenge an election?
it is not illegal to challenge an election through the proper channels, through courts. But what you can't do is, you can't call the Proud Boys to come to the Capitol.
Jen Ellis didn't do that.
Oh, well, I'm saying in general.
So we can, instead of I'm not here to argue January 6th. I'm arguing specifically the unprecedented action of arresting Trump's lawyers.
Well, if she committed a crime, just because you have a bar card doesn't give you a get out of jail free card. You're charged with. She was charged with 2 felonies, and she actually took a plea.
That's right.
Right, she pled guilty.
Indeed, because
lesser crime.
Pleading guilty always implies the guilty party is guilty, right?
Well, I'm a former prosecutor, so
of course not. Well, there's the trial tax and Jen Ellis's fear that there was no defense apparatus from a legal machine at the state and federal level willing to arrest lawyers. So she cowardly bent the knee and cried on TV and admitted to things when all she did was draft a letter. She wrote a letter for Trump. They charged her with RICO. And the bigger picture, I think, on all of this is show me the man, I'll show you the crime. And that's the ultimate point with the GOP Oversight Committee, with the pardons. We're looking at Letitia James on mortgage fraud now, Adam Schiff on mortgage fraud. And the argument from the other side is Trump is going after his political opponents. And I'm sitting here being like, and they went after him. What's the difference?
But you're talking about Fonnie Willis in Georgia. That's Indeed. Different than, right? That's not Joe Biden. That's not Merrick Garland. You're talking about Jenna Ellis, who the reason why she was prosecuted was because she was participating in lies that Rudy Giuliani made before Senate committees. And so if you lie, if you commit perjury, you're going to get bit for it. And that's why
she wrote a letter. I forgot, it was to a politician in Georgia requesting access or something, or challenging the election in some capacity. And this is the most egregious. They argued that, she was charged with specifically RICO, like a felony conspiracy involved in Trump's election schemes. But there was a lawyer in Wisconsin. It's ridiculous, right? So your political opponent, he's the front runner. Whatever the argument is, it is insane that they went after all of Trump's confidants, his staffers, and it does extend to J6, obviously not to anyone who was violent, but criminally charging people who weren't even there and giving them 20 years in prison, or even some of them that were for rioting, as well as people who got hunted down for misdemeanors.
Well, that's where the conspiracy comes in. We talked about that, seditious conspiracy. You didn't have to be there to be part of the conspiracy. I think you're talking about like Enrique Tarrio and people who weren't there on the scene. Right. That's the law.
And so I suppose the issue is we have a lot of laws on the books, and if the Democrats say let's rip precedent and throw it out the window, then Trump's going to respond with, I got a nuclear bomb waiting for you when I win the election.
I think what Merrick Garland, who's criticized by the left for being too timid and too weak, I think what he did was very different than what you're seeing now, where President Trump ordered Pam Bondi to prosecute his enemies, and then Bondi wavered on that. She didn't move forward on that because she's an experienced prosecutor. But then so Trump said, all right, I'm going to fire Eric Siebert, the acting U.S. attorney in the Eastern District of Virginia, because I don't like what he told me. He says there's not enough evidence. So then he appointed Lindsay Halligan for the sole purpose of prosecuting his enemies, James Comey and Letitia James. And so now you have the prospect of these cases being thrown out because of vindictive prosecution. And that's where the president needs to be careful, because when you directly order your prosecutors to prosecute your enemies, you're going to get a vindictive prosecution case. But when did that happen?
So we've got the E. Jean Carroll case, where they created a law specifically to allow just her to file a civil action.
But that's the state of New York. That's
Indeed.
not feds.
Indeed.
Right.
Well, the argument is the Democratic Party is not just a federal organization or a state organization. They're, in fact, both. And their leadership operates across the board, state and federal, and city and local and otherwise. But also you had the feds raided Trump's home. You had...
well, they had a warrant for that.
Sure. And then you've got the prosecution of Trump for documents, where they actually staged photos and put cover sheets on documents they pulled from boxes. And then Joe Biden, who actually explicitly was found to have retained national security information for the purpose of making money, was not charged because they said, we couldn't convict him anyway. The American people aren't going to tolerate it. Whatever your argument's going to be for the legal reasons, the American people see a story of Joe Biden withholding documents at multiple locations and them saying we can't charge him, and Donald Trump them raiding his home and saying, but him we can. The distinction in the minutia of like the granular legalese as to why it makes sense or doesn't matter in a partisan environment like we have right now. You can't do it. And that's why historically we've not seen a political party or political actors go after their top level rivals, like raiding the front runner's home in any way, it's nuts. Even if they did do something wrong.
Well, I'd have to.
Bolton too.
Bolton is a different matter. Bolton, I actually do think they have legitimate facts there. That's going to be tainted by the politicized prosecutions of Letitia James and James Comey, though. It feeds into that, even though Bolton looks like that may be a legitimate case. As far as raiding his home, I have to push back on the term raiding, because when they went in, first they got a search warrant signed by a federal magistrate showing there's probable cause that evidence of a crime existed in Mar-a-Lago. And then they didn't raid it. They went in there unarmed. They gave Secret Service a call in advance. They went in there with plain clothes and they searched the place and they recovered the documents that Trump and his lawyers said they didn't have. And so that was done the proper way. And then it went down. Jack Smith could have filed that case in Washington, D.C. That would have been so much better for him politically, because you have the liberal Washington, D.C. jury pool. You have the judges who are a lot more favorable. But instead, he filed it in South Florida, where he knew that Aileen Cannon, the Trump appointed judge, would be there and would possibly get the case. And that was the beginning of the end for him. It
seems like there's always some unfortunate legal reason why they're not going to go after the Democrats on these issues.
How so?
Well, like the Biden being the easiest example. We can look at the general unprecedented nature of, like I mentioned, the E. Jean Carroll case, where you're familiar. They created a law. They passed a law saying we're going to allow people to resurrect claims beyond the statute of limitations. It was used just for Trump. Highly dubious story. Or you also have the civil fraud case, where with Trump, they claim he defrauded because he had, documents misstated the size of his penthouse from 10,000 to 30,000, even though the financial paperwork submitted had the disclaimer, you must do your due diligence, the numbers may be inaccurate, as all financial paperwork does. And Deutsche Bank even said we weren't defrauded. So they launch all of these things, and then we're told there's actually no legal mechanism by which we can find accountability for these unjust actions.
I want to give you credit for the New York case. I want to say that one is something that I think a lot of people are now saying that was unduly politicized. That was the Alvin Bragg case.
The civil fraud.
The New York, there's
34 felonies, civil fraud, and E. Jean Carroll.
The 34 felonies.
They were all New York.
Yeah, that one, I mean, first off, Alvin Bragg and Letitia James both campaigned on going after Donald Trump. Yep. They both said you should never have done that. So I grant you that. And I think that in retrospect, that the New York case seemed to be a case where the DA was trying to find something there, and they resurrected this 34-count case. And I think that looked bad. And that was the first case against Donald Trump. That was not the Biden Justice Department, but that was Alvin Bragg, the prosecutor, making that decision. And I got to say, it's been my experience that when you're an independently elected district attorney, you're not getting calls from the White House to do things, because if that happened, I would have gotten calls because I had Mar-a-Lago in my jurisdiction. I never got a call from them and never even got invited to a Hanukkah party. But as far as the E. Jean Carroll case, that law that was passed in New York was not for Trump. That was done for sexual assault survivors. It was used against Harvey Weinstein. It was used against a lot of rich, powerful men. Trump did get caught up in it, and that statute was used against him. And it was interesting about that. That's how I first found out about you, Tim, in this podcast, because the jury selection. You remember when the jury?
That's right. They said they watched my show.
That was unbelievable.
One guy did.
Yeah.
To be fair, he said he's seen an episode of it or something like that. And then they tried claiming that he was a fan, but he just saw an episode one time or something.
The lawyers for E. Jean Carroll said you must remove this person from the jury because he watches Tim Pool podcast, and Tim Pool had talked about how bogus these cases were, and so the judge said, no, we're going to keep him on the jury. And then he ruled away with the rest of the
Because he wasn't really a viewer of the show, right? When you looked at what he had actually said, it's like I had something to the effect of like he had seen episodes of my podcast, but it wasn't like he was a regular viewer or anything.
I thought actually it was a sign of America's strength that you have people who watch your show and then decide as a member of the jury they're just going to follow the evidence and the law in front of them and then rule the way they did.
Thanks for checking out this clip from Timcast IRL. Make sure to watch the show live Monday through Friday at 8 p.m. Subscribe to this channel, and we will see you all there.